probably more than I'll be able to get through. Tasha will have a PDF of my presentation available, so I think she'll be able to send it out to the group. You can take notes as you like, but you won't have to write everything down that's on the PowerPoints. So about Iowa Legal Aid, some of you may know, some of you may not. Iowa Legal Aid is now a statewide nonprofit law firm, essentially, that focuses on providing legal assistance, civil legal assistance, to low-income Iowans generally, and also just folks who are generally vulnerable. There's so many different grants. The eligibility requirements for clients is always changing. So what I tell folks is, if you have somebody who needs civil legal services, just have them call the 1-800 number, see if they're eligible. If not, we'll refer them to the Iowa Bar Association. If they are, we can at least provide some advice and see how we may be able to help. And then there's, so about 2018, about 23% of our clients were seniors. And I have to say, so essentially my job right now is funded through Equal Justice Works, which is a nonprofit. They receive a grant from the Department of Justice that goes through the Office of Victims of Crimes. Anything I say today is my own opinion, not necessarily the opinion of Equal Justice Works, the DOJ, or the Office of Victims of Crimes. They help me do this work. And then I also want to give a plug to the National Center on Law and Elder Rights. They're an organization in DC, national organization, and some of the information I'll present today I received from them. They're also a good resource, have an excellent page. Iowa Legal Aid right now is in the process of helping them update their Iowa-specific information. So some of this stuff I'll go over quickly, because Tasha did a great job of presenting generally about elder abuse and risks and things like that. But I will say that financial elder abuse is one of the biggest, one of the things I focus on in my job. And there's some great resources. I want to thank Sandra from the University of Iowa Extension. She brought in a copy of this sheet that is front and back. It's put together by the Iowa ID Theft Victims Assistance Coalition, which is an Iowa organization, and I was on the committee that helped create this form. The idea was it's just simple front and back. You can print it off in your office and designed to be printed off in black and white or in color. And I'd probably forward a PDF to Tasha so she could send it out to you. There's a blank space up here so you can put your own agency's logo. Or if you'd like some help with that, you're welcome to email me. I have cards, just come up and ask me, and I can, or maybe Tasha can provide my email address and I can put that in there for you. But it's Iowa specific. And on the back table, I have booklets from the FTC about identity theft and fraud, and you can order your own. This one happens to be in Spanish. They come in different languages. It's really good, just kind of general resource. And then on the back table, the Iowa Legal Aid table is a handout for information on our senior hotline, and then our elder and financial abuse booklets, which I recommend everyone picking up just to kind of read through it, and it has our contact information as well. I think one of the main things with elder abuse and specifically financial exploitation is the differences between a known person versus a stranger. Tasha talked a little bit about this, but a lot of my clients, it's their son, it's their nephew. They know who's doing it, and that's one of the reasons often they don't want to report to law enforcement, but they want it to stop, or they want to help to mitigate the damage and recover as much as they can. I always advise my clients, it's certainly a good idea to contact law enforcement. They have more resources to investigate and to stop than I as a civil legal aid attorney do, but it's the client's decision. And then the stranger or new friend, I see this often too, and I kind of break this down into two parts. It's either, the neighbor, maybe the senior didn't know that well, ingratiates themselves to the senior, and asks for some money to help out with stuff, and over time, I have one client who's given over tens of thousands of dollars to somebody somebody he just met over the course of a few years. And those are really difficult to get that money back, especially when it may just kind of seems like that. But often these folks are scamming people. Then the other part of this kind of stranger thing are scammers, like Tasha talked about. And that kind of falls more into the general identity theft and fraud that can happen to anyone, really, where it's, Tasha did a great job pointing out all those different scams. And I think I'll skip over these next few ones. So whenever you're working with seniors, I would, there's some various things to kind of keep in mind with goal planning. I, as an attorney, have to goal plan with my clients. What do you want to see happen? And I'm sure all of you do as well. And there's different considerations to take into place. What is the senior's capacity? And capacity is not like they don't have capacity or they do have capacity. It can be a spectrum. And depending on your job or your involvement with the senior, what type of capacity you need may vary. I'm not going to go too much into specific types of capacity for each job today. That's just something to keep in mind. And basically, that's the senior's ability to make a decision for him or herself. Third parties, often in my line of work, the senior will come in with a friend, a neighbor, family member, because that person helps get them around, helps them with transportation, with managing tasks. I always kind of approach it with, I hope this person is helping them out. I trust that, but I try to carve out some time where I can meet with the person alone, the senior alone. Because I'm never sure, and I've had some instances where later, I kind of find out, maybe this third party isn't really as helpful as they appear to be. So I try to carve some time out to give the senior space to let me know if, how much they actually trust this other person or what their involvement is. And then there's mandatory and permissive reporting. So if you may have learned something, elder abuse, financial exploitation is part of that. Depending on your job, you may be a mandatory reporter, or in my case, it's permissive, but more restrictive. So that's just something else to keep in mind. There's APS in Iowa, and then the AG's office has a great page about elder abuse and resources as well. Kind of talked a little bit about capacity here. And I think I'll kind of go over this. I'll say this with third parties. That's something in particular to keep in mind when you're trying to identify somebody who may be the power of attorney for someone, or potentially a guardian or conservator. I'll get more into that here in a little bit. That's just, you kind of have, ultimately, a lot of the times, for power of attorney, it's up to the senior what they want to do. But you kind of have to use your judgment, and part of that's identifying the senior's capacity to understand things. So, goal planning. The rest of my presentation will kind of be split into two parts. The first part will be assuming that the senior, generally has the capacity to make decisions for him or herself, and then the next part will be if they don't, essentially, and then kind of recovering from harm or stopping elder abuse and financial exploitation. So I'm going to go over, these are kind of the voluntary things that stop short of either having a guardianship or conservatorship in place. It can be community-based services. Tasha talked about the community-based services the connection provides if the senior isn't eligible for an elderly waiver through DHS or the state. And then case management, like a healthcare facility, like a nursing home, skilled nursing care, assisted living, things like that. And then power of attorney, which is the power of attorney is the person who kind of is delegated the power to make decisions on behalf of the senior when that senior is no longer able to make those decisions for him or herself. There's an actual document. I think it's been a few years now, but the state of Iowa has a statute on it, and part of that statute is a form, or a suggested form. And Iowa Legal Aid does a lot of power of attorney for folks, and I think they're really helpful. You don't need to go through a court process to get it. Really, you could probably do it in an afternoon with the forms and an attorney. It doesn't take too much time, as long as you know who the parties will be, and I'll go into that more. A living will, that's a document, another written document, that provides guidance on what what the senior wants to have happen, should they maybe have a terminal illness or something like that. Durable power of attorney for healthcare, standby guardianship and conservatorship, banking options, trust, social security representative baby. I just realized I was explaining all these in greater detail, so go one by one. So community-based services, that's more like in-home care. The least restrictive means the senior's still in their home. There's different agencies that can provide that. And so, there's no really decision-making being made on the part of the senior, but it keeps the senior in their home. And case management, there's different agencies, again, that can help the senior manage essentially their life and things like that. And then healthcare facility, I talked about that. A living will, I talked about that. Now I went into the power of attorney here. Let's see. And I guess the main thing is that, so I would highly advise, I should probably have a power of attorney. We should all probably have a power of attorney. But especially when folks are maybe getting older, and if there's somebody in their life they trust, maybe a family member, a child, something like that, who would be able to jump in and make decisions should the senior lose capacity to make decisions for him or herself. I see this happen in my line of work where Iowa Legal Aid has partnerships with different hospitals in Cedar Rapids and Des Moines, I think Council Bluffs and some other areas, where somebody will be admitted and the physicians, the medical providers identify that they lack capacity. Usually they're diagnosed with dementia or something like that. And if that senior does not have a power of attorney, it makes it extremely difficult for the hospital and then probably later on the care facility to figure out what's going on with the senior's finances and things like that, and be eligible to release funds to pay for all of this and make decisions. So having a power of attorney in place, like I said, it's just a paper form, doesn't take that long to do, is highly, highly recommended. And as I was preparing for this, I was like, I should have these things, who knows, we could all have something happen to us. And so the power of attorney, it doesn't mean that once the senior signs it, that they can no longer make decisions for themselves. What it means is that should something happen to the senior where they're not able to make decisions for themselves, either short-term or long-term, that the person identified as the power of attorney can make those decisions. The nice thing about the power of attorney too is they can be revoked, and I'll go into that a little bit more later. So the nice thing about the forms that the legislature, as part of the statute, is that at the end of it, it identifies for the power of attorney what their duties are. So, because a lot of times, mom may say to her daughter, I want you to be my power of attorney. And I was like, great, that sounds good. I want to help you out, Mom. What does that mean? And so the forms actually kind of say what that duty is. They have a spot for the power of attorney to sign. I don't think it's required that they sign that, but it's extremely helpful. And then you name that person in the form. And then you can have like a backup power of attorney too, should that first power of attorney not be able to or choose not to later. And generally they have to act in good faith, and the forms kind of provide what types of decisions they can make. They shouldn't be abusing the power of attorney. We'll talk about what you can do if that happens. these are some of the things that kick in or that activate the power of or that terminate the power of attorney, actually. So if the senior or the person who had granted the power of attorney passes away, in a divorce, if your spouse was the power of attorney, that ends. Or like I said, if the power of attorney decides I'm not able or I don't want to do this anymore. And that can mean from they lose capacity, or they move a few states over, or they just have too much going on in their life and they can't take on that responsibility. And then the other thing is the senior can always revoke it. Like I said, I'll go into that more. And then there's the durable power of attorney for healthcare. I'll go back here. So this type of power of attorney that I've just been talking about has to do with financial decisions. The durable power of attorney for healthcare has to do with medical decisions. Earlier I talked about a living will. A living will, you know, the person writes it out. This is XYZ, what I want to have happen, ABC. With durable power of attorney for healthcare, there's somebody identified similar to the financial power of attorney that kicks in, and then that person is able to make decisions, kind of step in the shoes of the senior, make decisions on the senior's behalf, you know, in good faith, and usually according to kind of the options that medical professionals provide. Some other things, this gets a little bit more involved, and by that I mean, so there's a standby, guardianship, and conservatorship, and that requires a court process. And a lot of times people don't want to do that because it's just more time, more money, you get more folks involved, and to go into court, you would need an attorney probably to do that. So I'll just kind of back up here for a minute. A guardianship is where the court identifies a person to make decisions for you, for your well-being. And in a conservatorship, the court identifies somebody to make financial decisions for you, more or less. So in a standby guardianship, that just means that it's kind of similar to a power of attorney where it's not activated yet, but the court identifies somebody to be the guardian or be the conservator when the other person loses capacity. So that's a little bit more involved. This kind of gets back to some more simple options, banking options. You know, if the person generally is able to manage their own finances, but needs some help, like we all do probably, is automatic bill pay, direct deposits, banking by mail, phone, or the internet. So there, you know, a lot of this has to do with transportation issues, maybe kind of maybe slight memory issues, but not so much they lose capacity. This type of stuff will help them out. Or another banking issue is adding a trusted friend or family member to the bank account. Either the joint owner on the account or a signatory on the account. Those things can be helpful. This is also an area that you really have to trust this person, know them well. I have a few clients who this is an area where they're taken advantage of. Also with the power of attorney too. So it just has to be a decision that's that's well considered. And then trust. This is like a legal document that gets more involved. They won't go too much into this, but and there's all sorts of different types of trust. But a trust is where someone grants. So the senior would identify certain types of their assets to be held in the trust by the trustee who makes decisions about what to do with those assets in good faith and according to how the trust document spells out how they should do that. And then there's usually a beneficiary of the trust or beneficiaries where they can be receive the benefit of the trust. And then another thing this kind of gets in, so those things that I talked about were all voluntary. That's where the senior has capacity. They're kind of making decisions through this process to help them. So with the Social Security representative payee, it can be voluntary, And that's usually a good idea, especially when the senior's only income is some type of Social Security benefit, probably a lot of time retirement benefit, but it could be maybe they might receive, there's some different kinds, so they might receive those. Or if they aren't able to make decisions, then somebody from through the Social Security Administration could be appointed to help administer those their benefits. And so this is kind of the involuntary planning part of it, guardianship, conservatorship, and that's kind of, you know, there's not these other things in place. And so somebody needs to make a decision for the senior on who needs to step in and help them out. And so this is a court process. Like I said, guardianship, that's for the well-being of the person. Conservatorship, that's for financial decisions for that person. Oh, I will say, so then there is a standard for a guardianship. You can't just disagree that dad is, you know, donating too much money to PBS. That's not going to be good enough. You need to identify that without this guardianship or without this conservatorship, that it would result, well, for guardianships, it would result in illness or potentially death. It would result in harm to the person. So it's a pretty high standard, and that's because we don't want to be taking people's rights away to make decisions for themselves. So you'd have to file a petition in court. You'd have probably the person who would file the petition would be say, yeah, I want to be the guardian or I want to be the conservator, and then other folks would have the opportunity to come into court and say, no, it should be me. Ultimately, the judge makes the decision who the guardian or the conservator is, and that could be somebody else entirely. And the guardian and conservator, it can be an individual or it can be an agency. Throughout Iowa, there are different organizations that provide that. So I talked about these types of kind of planning things, voluntary, and then after the fact, involuntary. So now I'm going to kind of move in and talk about what happens when abuse is occurring, it's been identified. If the abuse is occurring by the power of attorney, if the power of attorney is perpetrating the abuse, then revocation of that is the first step. And then if it's being perpetrated by the guardian or conservator, then a termination or maybe a change of the guardian or conservator is appropriate. There are elder abuse protective orders in Iowa, which I'll go into. I listed evictions on here because while an elder abuse protective order can provide that the abuser must leave the home, maybe the person who's in the home, the senior won't qualify for an elder abuse protective order, so I'll talk about why evictions are good. Kind of a simple first step usually is either freezing or closing the bank accounts. If somebody's making unauthorized withdrawals from those, just to cut off access to that right away. And then I'll talk about recovery of funds through civil court, and then certainly, you know, contact law enforcement. And what point in the process you do that, or the senior decides to do that, depends on the circumstances. I mean, if it's, you know, obviously if it's a heinous, you know, or any type of physical abuse that's happening right now, call 911 immediately. If it's something they're not sure about, maybe they want to talk with an legal aid attorney, maybe they just want to report it. You can always go into your local law enforcement, police, sheriff, make a report. You should get a copy of that report. Then it's up to the law enforcement and county attorney how they want to prosecute that. Tasha made a good point. You know, sometimes these cases are really, especially identity theft and fraud and cases like that, are really tough to prosecute. Really tough to investigate. But I think reporting is always helpful because it can identify a pattern for law enforcement prosecutors to follow and you know, bring a stronger case against the abuser or monster. So revocation of a power of attorney, one key thing for this is just like the senior has to have capacity to establish the power of attorney, they also have to have capacity to revoke it as well. And more or less it's sending out these kind of form letters to the person who has the power of attorney. And it's also a great idea that if you left copies of it with your financial institutions, to send a copy of the revocation to them as well, so they know, Joe isn't supposed to be coming in withdrawing funds anymore. That's over. And then, yeah, there is a statute that provides for it in Iowa now. So termination of the guardianship. So upon a finding that the defendant has engaged in elder abuse, the court may, if requested by the plaintiff, order any of the following. This is language from the Elder Abuse Protective Order, but it is, I will say with the Elder Abuse Protective Order, I'll get into this a little bit more, but it's a little bit tough because if somebody files for an Elder Abuse Protective Order and the judge finds that the elder is eligible for one, the order can only say that the senior, has the right to make decisions. It's not kind of a way to get a quick guardianship or conservatorship. You would need to file a separate one. And then with terminating a guardianship, you have to go back into court, and the senior presents evidence to why it should be terminated. The guardian will present evidence as to why it should still be in place. And this is just, guardian can be removed for misusing funds or taking the ward's property. That's the person, the senior in this case. And then the court would select somebody else probably if the guardianship doesn't need to be terminated. So elder abuse protective orders, there are, so to get one, like the actual process, you just go to your county courthouse. This is a civil protective order. It's not in criminal court. And so somebody can go to the courthouse, there are forms, and they can fill it out on their own. You just you put your information in, you put in the abuser's information. There's a spot for you to write what happened, what the abuse is, what's your relationship to that other person, and then usually give it to the clerk or court administrator. Judge reviews it. I think often, each county is a little bit different, but often the judge will review it right then and there before the person leaves. And then either will, in most cases, if the judge thinks this person on the face, just based on what they wrote, qualifies for the elder abuse protective order, then they will issue a temporary elder abuse protective order that's in place until when the hearing is set. So a hearing will be set. The abuser should be served, usually by the sheriff's deputy if they can find him. And then at the hearing, the person who applied for it, the senior or their representative, will present evidence as to why the senior should be eligible for it. And then the other person, of course, would say why this should be in place. Then there's a note, yes, that's true. If the senior gets the elder abuse protective order, and then it's like, oh great, I have this piece of paper, what does that mean? If the abuser violates that, then you can file in court for a contempt, meaning that the abuser has violated this order, should be brought back into court, and then it would be up to the senior to show that this person violated the order, and the person could actually face some jail time. Usually it's relatively minimal, but some jail time. The more severe the violation of the order is, or if they do it multiple times, the punishment can increase as well. So these are the different types of things that are included in elder abuse. Of course, physical injury, unreasonable confinement, punishment or assault, sexual offense, neglect, which is deprivation of necessary care by a caretaker, and financial exploitation. So financial exploitation is elder abuse, it's just one of the types of elder abuse. I kind of talked a little bit about this, temporary protective order. Another thing is, if the judge grants, you go to the hearing, judge decides you should get the protective order, that's in place for usually a maximum of 1 year. Most of the time it's going to be 1 year. And then usually you can file to extend it within that 1 year period before it expires, usually within the last 6 months. You can file to have a hearing. At the hearing, you explain to the judge why it should be extended. The elder abuse protective order is relatively new, so I personally don't know what judges are looking for the elder abuse protective order to extend it. I don't know if there's a lot of case law on this, but I would think an analogous would be in domestic abuse protective orders, where the Iowa Court of Appeals has found that within that 1 year period, the abuser doesn't need to abuse again in order to have an extension. The person just has to have, the judge just has to think that there's a chance it could happen again and that it's, safe. It would increase the safety of the protected party, and it's not going to restrict the rights of the other person, so much, kind of just balancing the factors. So this talks about if the judge, so the first step is the judge deciding you should get the elder abuse protective order. That's the first step, and that's the most important thing. And then, as part of the hearing, you can let the judge know, Judge, if you grant me this elder abuse protective order, this is what I would like to do for relief. This is what I'd like you to grant in order for relief. So personal safety, usually that means abuser, stay away from my work, stay away from my residence, don't come around me in person. And that can include not quite eviction, but saying like, if you're living with me, you can't live here anymore. And then it can also provide for like, let me see if I wrote it in here. It can provide for a lot of things actually. In the statute, it says it can provide for a lot of things. It can provide for blocking somebody from being able to use a bank account. It can say can't make financial decisions for this person anymore. The statute, on the face of it, allows a judge to say, oh yeah, this person committed financial abuse against the senior. Senior qualifies for an elder abuse protective order. This person misappropriated or stole, $20,000 from the senior. And I think the statute itself could allow the judge to say, abuser, you are ordered to pay back the $20,000. I think in Iowa, we've been seeing a lot of times judges are saying, you get the elder abuse protective order, the wrong's been done, this protective order keeps you safe, keeps the abuser away, but it's not. In this hearing, it's usually scheduled for 15 minutes, or they might go for a little bit longer. But in this hearing, the judge, am not going to decide this kind of this monetary claim. You need to file a separate action, maybe in small claims court or district court, depending on the money, to get that money back. And I think that's up to the judge's discretion. I think a lot of times, because like I said, these hearings are focused on whether a protective order should be granted, not so much on all these other claims, which can take a long time to hear. And elder abuse protective order hearing isn't really set up to decide what it could buy for a lawsuit for $40,000, $20,000 in district court. I mean, that could take a year or more to figure all that out. So, in these protective orders, usually somebody files and the hearings within a couple of weeks. I would say, so we talked about like somebody misappropriated money. If the abuser, took some of their property, like actually has it in possession, and I can see that come up like as part of the abuse. Somebody is withholding, kind of sentimental things from somebody, or maybe it might be their phone or computer or something like that. The protective order can't say you are required to return this property to the senior within however many days. I would argue as short as possible. Sorry, it's cut off here, and I think when I email it out to Tasha, I'll fix that, so you'll have that. But in order to be eligible for an elder abuse protective order, one, the person applying for it has to be a senior, and then two, the abuser has to be somebody, like it says down here, stands in trust or confidence. It has to be the right type of person. Usually it's a family member or a caregiver. It can't just be, unfortunately, sometimes it's not, your neighbor who the senior maybe gave money to or was kind of maybe taken advantage of by, if the neighbor says, yeah, will you help me, give me $5,000 and I really need it for a new car and then I can drive you around, things like that. That neighbor may not really stand in the confidential relationship, and so an elder abuse protective order may not be appropriate. I'll talk about some of the other legal remedies that somebody can get into. And these types of gray, what I call like kind of gray area cases, are really, really tough. Gray area case is one in that this, I'll use the term kind of broadly, the abuser doesn't meet the definition of an abuser for an elder abuse protective order. That's really tough. The other part of it is like kind of that scenario where I just described, where neighbor ingratiates himself with the senior. Senior's kind-hearted, generous, says, "Oh, I'll help you out," gives some money, and really the senior's being taken advantage of. It can be very difficult to get that money back because it wasn't a gift. It's not really like a contract. What was going on here? It's not necessarily fraud. It's really difficult. So that's just kind of what we talked about. I touched on this earlier, but I'll just kind of bring it to your attention again. In the elder abuse protective order, the court cannot allow anyone other than the vulnerable elder to take responsibility for his or her actual finances or affairs. You would need to set up, go back to court for a guardianship or conservatorship if that person wasn't able to make the decision for him or herself. I will say another factor for an elder abuse protective order is that it's not just that the person is a senior, but they have some type of condition which made them vulnerable to the abuse. A few years ago, the Iowa Supreme Court, there was an Iowa Supreme Court case, the Iowa Supreme Court's opinion was that, yeah, if somebody is just of a certain age, that means that they can qualify for an elder abuse protective order. They don't have to have a showing of anything more than that. The state legislature passed a law this year, I think it went into effect on June 1st, that says, so they changed the statute, the elder abuse statute, and it says, yes, in fact, you do have to show something more than just the person was a senior. And I think when that Iowa Supreme Court decision came out, some people were like, yes, this is great. Some people were like, well, it seems kind of derogatory towards seniors. But, as somebody who represents, I kind of want more broad interpretation of when somebody can get an elder abuse protective order, because those are typically my clients. And I think for the past almost like a month now, it seems this kind of a side note, just my own opinion. The NPR has been running a really great series on aging and about elder abuse. and about decision making and things like that. So it's probably available on the website. The managing attorney of the elder, the senior hotline that I did sent me some information about that. It'd be really interesting, driving around, download it and listen to it. And just, I kind of mentioned this earlier, but somebody can be found in contempt of the Elder Abuse Protective Order, which is a quasi-criminal case, civil protective order, but the court's enforcing it, so violation, punishment could be jail time. And then, usually I think, I could be wrong about this, I apologize, but I think with Elder Abuse Protective Orders, there's no cost to the person filing it, to the elder filing it. The cost could be assessed to the respondent in the case of the abuser, which is nice, because so it's not a deterrent for people going in to file. Because most of the time when you go into court, in civil court, you file a guardianship, you file for conservatorship, that person has to pay the filing fees and court costs later to be divided. But some people are like, I don't have the money to do that right now, so they don't want to do that. For the protective orders, that's good. My next slide moves on to something else, so I'll finish up protective orders with this. I talked a lot about elder abuse protective orders, but those are like really, really good because they're kind of more broad in what qualifies as abuse. But if a family member is abusing a senior, physically abusing a senior, they can qualify for a domestic abuse protective order. So the relationship is a little bit different to establish to get that. They can also apply for one of the relatively new sexual assault protective orders if that's the type of abuse that's going on as well. And then I'll just kind of briefly talk about evictions. So if a protective order isn't available, say hypothetically, son's living with mom wants him out of the house, she's taking advantage of him, she could evict him. If he's actually a tenant, like under the Iowa landlord-tenant law, and mom's a landlord, that can become kind of more of a legal, like they just have to go through more of a process. If son's just been living there for a while, my opinion of this current standing of the law is mom go into court, file for a forcible entry and detainer action, and just go through that process. Usually Iowa legal aid represents tenants, but we have from time to time represented usually often it's parents of kids that are taking advantage or actually physically abusive. Freeze or close bank accounts. I mean, that's really all there is to say about that. If the person has the capacity or authority to freeze or close their own bank account, or if the power of attorney or who's not doing the abuse has the power of conservative guardian to close or freeze the bank accounts. I think that's a great first step, because often in these cases, you just need to cut off the flow of money. You just need to cut off the flow of abuse, punishing the person for doing it, clawing back whatever money you can if possible is a longer-term process. You just need to stop the bleeding. So here are some of the civil remedies for recovering funds from the abuser. So if the perpetrator was in a fiduciary relationship with the senior, then that abuser could be subject to prove that they properly handled the funds and the property of the senior by supplying records and information. So that's like a request for an accounting. And that's often a really good first step too, especially if you aren't 100% sure what's going on. Getting a letter, the power of attorney gets a letter, or the guardian or conservator gets a letter, or somebody else who fits in the category of having a fiduciary relationship with the client. Client gets a letter, request for accounting. That's a good first step because it could kind of freeze the abuse. Also, you should like, ideally make it simple because you should get all the bank records from them, let them do the legwork, and then you can review it with your client or whoever else has authority to help out your Undue influence. So there's a presumption of undue influence if there's a fiduciary relationship, opportunity, and benefit to the person committing the abuse. Deceptive control and manipulation exerted through undue influence. Prevent the subject, in this case the senior, from knowing the true nature and act, and acting freely and voluntary. This can be, so this is like something that may be able to use if there were assets transferred. This isn't the strongest claim. There's a high standard of proof, and it can be hard to prove, what undue influence is. I think it's one of those things where, was it manipulative? Was this person misleading them? It's often up to the judgment of the court to decide what was going on. And so this one example is if the abuser has a joint bank account or signed an agreement to transfer the funds to the other party. Breach of fiduciary duty. So that is if somebody, I kind of talked about this a little bit earlier, but if somebody has a fiduciary relationship with their client, so if they're like the executor or trustee of the trust or conservator, guardian, power of attorney, with a fiduciary relationship, it can kind of vary depending on what area of law you're talking about. But basically it means like you have to, it's even your relationship to, so we'll use the phrases we're using today. Say it's the power of attorney. As a power of attorney, you aren't just like performing like what you would do for yourself. You even have a higher standard to do the best thing possible, the best interest of this person. You have a great responsibility of taking care of it. And so a breach of that can result in maybe being able to recover some of the money back or get property back, or undoing transactions that were detrimental to the senior. So the Iowa Code says, no fiduciary shall in any manner engage in self-dealing, except on order of the court, and no sole interest of the interested persons, and shall derive no profit other than the fiduciary's distributed share of the estate. So that basically means like, say it's like somebody who's the trustee in the trust. And part of the trust is that the senior wanted to donate their money to a local nonprofit to take care of a park. It's a city park. Senior loved going there when they were a kid, loved taking their kids there, and really wants to help out that park for future generations. And then the trustee is like, oh, I have an idea. I'll be able to pay myself. I'm going to create this. I'm going to say, maybe they might create a business, or say I have this business that goes and cleans up the park once a month, and then pays themselves an exorbitant amount of money, or maybe it's not even an exorbitant amount. Maybe it's just not really, fair. That's a breach of the fiduciary duty, just one example. Conversion and fraud. These are kind of, fraud can be a criminal violation. In this context, we're talking about like in civil courts, there's just common law fraud. In conversion is just essentially like theft, but in civil court. So you can sue somebody to get that money back, essentially in civil court. This doesn't mean that law enforcement, county attorney can't actually, they can still prosecute people for theft, for fraud, if it meets the criminal statute definition. But you, the person, senior, can actually sue the person as well. And I will say that we talked a little bit about identity theft before. In Iowa, not all states have this, but in Iowa, a private individual can sue somebody if they've committed identity theft, which is like if you can actually figure out who did it, which is usually not the case, but you can sue them to get the money back. For identity theft, for both the criminal and civil definition, it's just when somebody misuses or takes somebody else's personal information and then uses it without authorization for a gain. It can be financial or other types of things. To get housing, to get, so their name's not on a, they don't have a criminal record, things like that. This goes into a little bit more detail. So associated legal issues. In Iowa Legal Aid, we do a lot of different civil legal things. So sometimes when I'm talking to a client, they may come into me to talk about A, and through our conversation, I identify B, C, D, so on and so forth. I say, this seems like it might be an issue. Would you like some advice about it? Maybe we can assist you with that. So these different kind of things come up. Medicaid, consumer law, income maintenance, benefits, housing, other things can come up. And I will say that, you know, if somebody comes in and says, you know, my power of attorney stole $20,000 from my bank account, I assure you that the senior is also probably going to have, you know, they're going to have problems with housing, they're going to have problems with probably food, utility bills, different things like that, all of which may not have an immediate, may have a legal solution, or maybe they'll have some issues legally, but then we can refer them to other service providers for some short-term assistance. And then there's a whole other world with criminal law, with crime victims compensation and restitution, and I'll leave that to our next speaker. So, yeah, a couple minutes for questions if anyone has